All right. Welcome everyone to Sprinkles Parents. I'm Brooke Shapiro, and thank you so much for attending today. For those who don't know what Sprinkles Parents is, we are a community in the Bay Area that provides education, activities, and resources to families with young kids to help in however we can. As we know, parenting is really hard, especially those of us who've made it through the pandemic. And I'm so grateful today to be talking about estate planning with Patricia from Defonte Law. Did I say that properly? Awesome.
Yes.
And she's going to help share with us some tips so we can set our kids up for success as we think about our estate planning, we think about our kids' future. God forbid anything would happen. So, with that, I am going to kick it over to Patricia.
Thank you so much for everybody just taking the time to actually do something like this today. It's Friday. Happy Mother's Day. That's coming up. So I know that we're not all just going to sit around and wait for something magical to happen. We're probably all helping set our children up for success for Mother's Day. It would help me to know if you guys could drop into the chat, ladies, who has tried to create an estate plan before or who has created an estate plan before. That would be really helpful. And if there's anything at all that you are wondering about, please do put that in the chat. And you can send me a private chat if you don't want to put it in front of the group, or you can just put it into the general everyone chat. No, okay, I'm not
I
seeing anything in
started
the
and I
chat.
never finished, to be
You
completely
started and you
honest.
never finished.
My
That's
husband
really
and I could
typical.
not agree. We went back and forth, and then finally we just never finished it.
Um, and I'd love to know why you came here today. What is it that you're trying to get out of this workshop? And then we'll make sure that we're hitting all the right notes. I talk about this on the fly. I talk about this all the time. And so I do have a PowerPoint presentation that we're going to go through, but we're flexible. I'm not going to read you a bunch of slides. Okay, that is very boring. And I'm going to ask you for a favor. At the end of this, a QR code is going to come up and it's going to take you to where you could leave a Google review. We have a new media director. I would really appreciate a Google review because she keeps talking to me about it. And I keep telling her, but I have a sandwich board in front of my office. Isn't that good enough? She says no. She says, no, that's not good enough. So I'm going to go ahead and but first I want to introduce my senior associate is here today. Her name's Nadia Spivak. She's been a lawyer for over 20 years, just as I have, and she's been with the firm for 3 or 4 years now. Usually we have an administrative assistant come to these workshops with us, but our administrative assistants are off preparing for their own Mother's Day. So they can't be here today. So forgive us if we are not beautifully on point when we say we're going to share links, but the lawyers, are going to muddle through the technical side of doing this presentation without our usual helpers. And let me set this up so that I can see the chat. Okay, great. Uh-oh. There we go. Okay, so this is just estate planning fundamentals, and the tagline for my firm is estate planning with heart. So it's not just a tagline that some marketing person made up. For me, it's very real, and it means that we're paying attention. We're not asking you to fill out a bunch of forms, and then we use those forms to draft documents, and then asking you, do you have any questions on those 500 pages? We're really taking the time to learn a lot about you, create documents that are very specific to your family, your loved ones, and to you. And then we don't disappear over time. You're not going to hear one of our clients say, oh, we never heard from our estate planning lawyer again. We just don't think that that's helpful. So I have to do this disclaimer. I can't give anybody here any legal advice. You may have really specific questions that you want to ask me. I can't answer them. The only way that I can give legal advice is to a client who has signed our fee agreement, and then I ask them a million questions, and then I apply their answers to the law. It's the only way to do it. So today we're just going to talk about generalities when it comes to the law, kind of overall best practices. this is me, and this is why you can rely on on what I'm going to talk about today. My firm has a torture word for ethics from the Better Business Bureau. We keep winning Best in the Bay. We never campaign for it ever. It just keeps happening. And the first time we didn't even know that it had happened, one of my colleagues called to congratulate me. Super lawyers, this is peer review. So super lawyers is really touching for me because it's not something you can campaign for, and it's something where other lawyers are rating you. And I've gotten that designation for the last 3 years, and they will announce 2024 in June. I've also contributed a chapter to a book about various aspects of estate planning, and my chapter was on divorce. It is a lie and a myth and a problem. This idea that you can't have a new estate plan until your divorce is final, it's just wrong, but that's a whole other workshop. Okay. So let's pretend that I will discuss, yes, I will. So if you don't have a plan, you haven't done anything, you haven't signed any documents, this is who gets your stuff. So you all found me through Sprinkles, so all of you have children. Not all of you have a spouse. So if you die, everything goes to your children. Now, the trick is with minor children, the law does not actually allow them to inherit. So what happens? They don't know what happens because a judge decides what happens. And James Gandolfini, the judge for his case, decided that his daughter could have all of the money when she turned 18. Other judges give the money to the other surviving parent. Other judges give the money to whoever the guardian might be. Other judges put all the assets into a locked box and say the child can have them at 18 or 25. We just don't know what a judge is going to do. They have full authority and discretion. If you have a spouse and one child, people generally tend to think, well, if I die, everything will go to my spouse. But it's not necessarily true. Your community property will go to your spouse. But if not everything that you own is a marital asset, maybe you came into your marriage with money and you haven't mixed it up with your married money. Maybe since you've been married, you've received a gift or an inheritance, a personal injury award, so you have some separate property. So you can find yourself here and figure out, well, if I do nothing, who gets my stuff? So what if I have more than $184,500? And this is 184,500, it's that number with cars, jewelry, tools, equipment, RSUs that if you haven't done a transfer on death beneficiary, a bank account if you haven't done a transfer on death beneficiary, a life insurance policy where you name someone, but they're dead and you didn't have a contingent. This is when the law doesn't know who to give things. You haven't said, when I die, this goes to so-and-so. And there's more than $184,500 worth of that stuff, then we're in probate. Generally, the numbers I like to look at are if you own real estate in a major metropolitan area in California. If you have a property that's $1 million, then the lawyer and the executor each get paid $23,000, so a total of 46. And that's just what the statute says that they get. If they have to do something that's a little bit complicated, like selling a house, then they're going to get paid more. And this does not include all of the court fees and publication fees and to their costs on costs on costs if you die without doing anything. These are also the costs that are associated if you die with a will. And so you kind of find yourself, if you're a real estate owner, and on my website, I have a probate calculator. So if you want to punch in the actual amount for your home, you can do that on my website. And Nadia can put in, she can put in the chat, the link to our probate calculator. So who decides what happens to children? The judge. The judge decides. And generally, the rule is children are placed where it's necessary and convenient. So what's the typical scenario? It's date night. And let's say that you're coming home, but you're not coming home that night. So the police officers go to your home. Their children are home with a teenage babysitter. They can't stay with a minor. So where are the children going? generally the police are going to call Child Protective Services unless a close family member or someone, a neighbor who seems to know the family well, says, I'll take them. And this is generally for California residents. I'm a California lawyer, and most of what I'm talking about here applies to California residents. The probate numbers that I shared with you earlier, those are 100% California. This, what happens to my children, I think is pretty basic nationwide. I'm a California lawyer and I talk about California law.
So I guess the question though more so is, Patricia, like if we're parents, excuse me, in California, but our family member is in another state. So how does that apply when, like, I think thinking about it across states, like my family's in Connecticut, I'm here in California, God forbid something happens. How do you think
So,
of,
right. So I'm just right now talking about if you
yeah,
do nothing, this is what happens. And
got
so
it.
if you're in California and there is no one to come immediately to take the children, they're going to Child Protective Services until your people arrive, and then they start the court process to get them out.
Got it.
So it's
Thank you.
really, really important to find and name some good local people.
Yeah. Thanks.
Yeah,
That's
that's a
very
great
helpful.
question.
I also know a lot of us in this group are overwhelmed by like thinking about this. And so I just want to reassure everyone we're not trying to scare you or
No,
anything like that.
no,
I
no,
think it's
no.
really important that everyone knows that we're just trying to like to share basic information so that you're aware, and then you can talk through and are prepared accordingly.
I love
Because it
that.
is very overwhelming, we had talked about, and that's why I wanted to do the session.
It does feel overwhelming. The scary part of all of this is these are the default California rules. This is the estate plan that we all have until we opt out of it. And it is rough going. It's just not nice. And so I didn't think that it would be fair of me to just jump into how to do a beautiful estate plan that protects your family. You kind of have to know what the default is and the laws that you're working against, what you're up against when you try to do this.
Definitely.
And I don't know states that are more friendly. Some states are more friendly for probate, but no states are more friendly for guardianship that I'm aware of. So what happens if you lose capacity? You're in an accident, stroke, something happens. Conservatorship. And we've all heard about conservatorship, right? We've all heard about it with Britney Spears, which was a very extreme case. Maybe you've seen recently that Jay Leno has been in the news for conservatorship for his wife. And what it means is that you can't act for yourself anymore, and someone else needs to step in and really step into your shoes and start making decisions for you and acting for you. Conservatorship is expensive and it's 100% public. And the person, hopefully it's someone who really loves you, has to go to the judge in open court and say, this is what's happening with her, and list all your frailties. And then a judge decides how much authority they're going to give the other person. Sometimes it's really necessary. A family member just has an accident. They haven't gotten their documents in place, and we need to get to their money. We need to make healthcare decisions for them to protect them. But it's never easy, and it's pretty traumatic for everybody involved. And so we definitely want to get away from a potential conservatorship. These are the things I hear all the time. The estate planning is for elderly people and for rich people. And yes, old people and rich people can have estate planning. I don't mind. Another thing I hear all the time is, oh, I trust my people to do the right thing. My documents don't need to be hyper specific. People know what to do. They'll know whether to bury me or cremate me. Maybe we could write it down. I like things to be really specific. Estate planning is not complicated. So we just touched on the California default plan, which just answers 3 questions. What about my kids? If I don't do anything, they wind up as part of the system, and then the guardians will have to get them out of there. If we don't do anything, there's number 2, what about me? How do I avoid being conserved? And number 3, what about my stuff? How do I make sure that it's not going through that court process, which in California takes a long time, it's really expensive, and it's completely public? So it's really just, what about me? What about my stuff? What about my kids? And everything in estate planning, no matter how simple or complicated the plan is, fits into those three silos: me, my stuff, my kids. And then estate plan from 10 years ago is okay. So I'm sure a lot of you have talked to the older generation and they say, oh, I did my estate plan ages ago. It's fine. It's great. It's probably not. Congress is always doing something. The California legislature, and I'm sure states all over the place, are always doing something. And then a judge somewhere might be doing something. And also, people change, right? And so you might not be happy with what you wrote down 10 years ago. It just might not make sense for the way your life is now. So don't let your people get away with, oh, we did it ages ago. Make sure, especially for your moms, that they have 100% up-to-date estate plans that with trusts that are fully funded and everything is absolutely perfect. So how do we get out of this terrible California default plan? We avoid probate. By using irrevocable trust, we get privacy, so nobody knows what we died with. We get to protect a surviving spouse or partner by protecting their privacy, but also in a well-drafted trust, they're going to have some asset protection ability and some tax planning ability. We don't know what the laws are going to be when we die. We don't know when we're going to die. 5 years, 10 years, 50 years. We don't know what Congress and our local legislature will have done. And so we really need to leave that surviving spouse the ability to have some maneuverability when it comes to tax and asset protection. I really love control from the grave. What is the best, highest use of money? Super important. I don't like trusts that say you get your money when you're 25, 30, and 35. Imagine some of you here work in tech and you're getting RSUs. Now imagine that you are the beneficiary of a trust, then you became the beneficiary when you were 31. So now you're waiting for that next amount of money at 35, right? During these 4 years, that money, there's a lot of tax that's being associated with that money. When you're 35, it's forced out of the trust, and maybe that's the year of the IPO. Maybe you have RSUs. So now you have two tax problems that you can't control at all. And who's the winner? The IRS is the winner. I don't like it when the IRS is the winner. And of course, we always have to worry about, that dark tunnel of bad things that can happen. What if at 35, the person has creditor problems or they're going through divorce, but maybe they've grown up to be an anesthesiologist or a contractor, a profession where they tend to get sued all the time. They might prefer to leave all their assets in the trust, leave their inheritance in the trust so that it better protects them and it better protects their family. Brooke's note in the chat is really, really important, and I'm a huge fan of LastPass, and that's part of the support that we do give our clients is after they've signed their documents, we do talk to them about all of the aggregators for passwords, because you really don't want people hacking into your email, because the very first thing they'll do is they are going to do a search for their own name. So if you have mean things written in your emails, please delete them, because when you die, everyone will find them.
Yeah, and
Choosing
like
the right.
Facebook accounts too, I think like that, like for communication, if like again, your parents or God forbid a spouse or whatever, just having all those passwords so you can access everything versus scrambling, I think is something also really important as part of the estate process, like you were saying.
Critical. And with some platforms, you can name the next in line. You can do that with Facebook, you can do that with Google, you can do that with Apple, but you can't do it with everything. And so it takes a little bit of work to get all of that in place. And we provide support around that. We have an email with links and articles, and it's all, it's kind of a changing landscape, but it's definitely something that's really important to think about. So how do you choose people to serve as your successor trustee? Who is this person who's going to manage your assets if you bump your head and after you die? You have to make sure that they're going to get along with the other people. You don't want the person who is in control of your money to not have a good relationship with the person who's making medical decisions for you, or after you die, you don't want the person who's in charge of managing the children's money to have a conflict with the guardians of the children, to make sure that you're choosing people who get along and respect each other. Generally, a revocable trust, the person needs to be a US citizen who resides in the United States. And we work with a lot of green card holders, and this can be a pain point. We promise you, we will help you find someone. There is someone in almost everybody's life who can do this work for them. And it's very, very important for those of you who may have an estate plan, or when you talk to the older generation or other people, make sure that everything has been properly titled, all the beneficiary changes have been made, and that this trust is actually going to work when the time comes. So how do we avoid a conservatorship? There are two main documents that we're going to sign. We're going to sign a healthcare directive, and we're going to sign a power of attorney. Those are the two things that are going to help us avoid conservatorship. Generally, a healthcare directive, and I do want you to take notes on this, because you can get an advanced healthcare directive from your doctor, from CPMC, Stanford, UCSF. You can Google California Statutory Healthcare Directive, and it pops right up. You can write it on the back of a napkin. You can use any form you like for your healthcare directive. Most of them say, here's who's in charge, pull the plug or don't, I want to be buried or cremated, and here's what to do. That's kind of it. It's really all they say. So I want you to add a few things. It's really important if you have minor children to say, I don't want to be used as a cadaver. I have clients who work at Genentech and say that you should not let people extract genetic materials from your body to create a sentient being. For couples who are going through IVF, this can be really touchy, because what are we doing with the genetic materials? If you've been going through an IVF cycle and you're terminal, can your partner extract your eggs? And so these are generally conversations that you haven't had with the clinic, and they can be a little tough and a little bit delicate. Who to keep out of the room is actually popular. My clients who are divorcing or divorced, the co-parent can be on the floor, but they can't be in the room. They can be on the floor only to comfort the children, but they can't be in the room. Your sister, who is an agent of chaos, cannot be anywhere near the place. And what you want to do is you want to write it down. You don't want to think to yourself, well, my person knows not to let Francine in the room. Just write it down. And then your person just shows Francine, look, I'm not kicking you out. You are kicked out. It is written here. And then they don't have to argue. Similar, if you don't share a religious faith and tradition with your spouse or partner, with your parents, you have to be really specific about that. Is it okay for them to come in with clergy? Is it okay if they're Catholic but you're not? Are you okay with some of the last rites, all of the last rites, none of the last rites? It's really important to get hyper specific. List your underlying medical conditions. Pregnancy provisions are really important, especially considering the state of reproductive health law in the US. And LGBT plus considerations are critical. There is a recloseting of patients, especially when they can't fully fend for themselves. And so our documents across the board say that for our LGBT plus clients, that the agents have to find LGBT plus competent and friendly providers. So this you can do on your own. And I encourage you, please do this on your own, and also collect these from your parents. If you think that you're named on anyone's documents, or if you're going to be in the hospital, if something happens to someone, ask them. And if there's anything there that you don't understand or anything that might be controversial, talk about it now. Don't wait until the time comes. The
I
other
feel like this
part,
would have been, oh, sorry, I was just gonna say for
yeah,
anyone here who's having more children, I feel like I wish I had done this almost when I was pregnant. Be like, this person can't be in the room. This person leave me alone. No, I don't want like all of a sudden like the clergy to come into the hospital room busting in. I feel like this all would have been very good to have from the religion standpoint, all when pregnant too, right? So that it's starting really clear early on. So I
I
love
think that's a
this.
great point. And I think that there should be a big sign on the outside of the door saying, not you. So that people come in. It felt like a
Exactly.
revolving door when I had my kids.
Yeah,
The,
totally.
the second part of conservatorship is trickier, and it's a power of attorney. You can find these all over the place online. What I'm telling you is that they're not going to work. If you must, then the California AG's office has a California statutory form. It's called the California Uniform Power of Attorney, but the banks don't like it. They're generally thinking, whoever signed this, the person that signed it, maybe they signed it under duress. Maybe they didn't understand what they were signing. What they're looking for is an attorney's counter signature so that they have some comfort that the person actually understood what they were signing. I've gotten calls over the years from colleagues in financial advisors, insurance brokers, who told me my client is sitting here and they're showing me a power of attorney that they don't remember signing. Okay, one of two things. They have lost capacity and don't remember signing it, or someone put this under their nose and something tricky, something weird is going on here. And so they have to dig a little bit deeper. And whenever a bank has to dig a little bit deeper, then the document goes to the legal department and we never hear from them again. And so for a power of attorney, I think it's really important to work with a lawyer. You can also go to your various banks and ask them, do you have your own form of power of attorney? What are my options with you, with your financial institution? What can I do? Nominating guardians. Okay, this is a big one. The old way to do it is you name them in a will. Now, I don't like wills because probate and they're public, it takes forever and it's expensive. It's the public part that when it comes to guardians really gets me. So your co-parent dies and the will might say, if it's drafted by most people, it will name your children, provide their birth dates, name the guardians, and provide their contact information. And so now here you are at home alone. And I'm sorry, this is scary, but this is the worst case scenario. You're home alone, grieving with 2 little kids, 3 little kids, and weirdos are contacting you and the guardians, fishing for more information. It's really important that we safeguard the privacy of the surviving parent and of the children and of the ultimate, later guardians. Even if you have a trust, you have a will, it's just a technical document. You don't have to worry about it. It doesn't really, it's not like in the movies where there's the reading of the will. It doesn't say much. And in California, we don't have to list any of that information. We can do it all in a separate document and just notify the court that, Your Honor, we're using a separate document. So you can just stamp this and put it in your outbox. No probate here, and we're doing guardianship a different way. At my firm, we have it starts at 6 pages, the guardianship nomination form, and we're listing emergency contacts because another thing a will won't do is help you while you're alive. So if you've bumped your head and we need interim guardians, then they're listed there and it's effective. We're going to list who you nominate for your guardians and why, and then we're going to list a whole bunch more information. How do you feel about religion, education, firearms, social media? Have you stored cord blood? Who are your best friends? Which family members do you want your children to spend time with? What are your traditions? More information. Why? Number one, something happens to one parent, the other one has it. They have that parenting statement forever. And we've heard back on that from many single. If we work with just one parent because they're no longer with their co-parent, they deliver this document to the co-parent, and the co-parent consistently have said, if the worst thing happens, I'm so grateful I have this. This is really helpful. And it's even helpful today, just to see written down what is so important to you. Number two, it's a guide for your guardians, right? Maybe it's not appropriate at 8 years old for your child to talk to your best friend from college, but they're going to want to when they're older, and they're going to want all the stories. The third part is the judge, because you get to appoint whoever's in charge of you, and you get to appoint whoever's in charge of your money and your taxes and your mortgage and your insurance. But you nominate the guardians of your children, and a judge decides who's actually going to serve in that role. And so what we want to do is we want to provide all the information for a judge. So when they're doing their independent investigation to determine what's in the best interest of the child, we are guiding that investigation. And it is always the most touching and the sweetest and the cutest part of the entire estate plan. I absolutely love it. Our plans always include a provision when the children are minor that they can the trust funds can be used for family harmony and togetherness. And so all the people that you've named in your nomination of guardians, Aunt so-and-so and grandma and cousin it and siblings, the trust can pay for your children to go and see them, or if for those people to come and see your children, if otherwise the finances don't work out. Family harmony, togetherness, social emotional well-being, that's critical. And any estate plan can be wonderful when it comes to tax efficiency. Oh, it's bulletproof when it comes to asset, like whatever. But who cares if we're not actually taking care of the people that we really want to take care of? If we're not drafting a trust that says we'll pay for your lawyers and CPAs and financial advisors, if we're not drafting a trust that says we want you to get out and self-actualize, don't be afraid of your money. The successor trustee is here to help you. There are lots of guidelines here, and we want you to go out and have a rich life. And that's the point of estate planning. And it really starts with the nomination of guardians, with all that really heartfelt work. And then it all gets woven together with the revocable trust to provide really a vision and a mission statement for your family. And that's why estate planning for me and for Nadia is not boring. If all we did was tax efficient estate planning, first of all, we'd probably only work 2 hours a day, never talk to our clients, and be completely bored. This is the heart of what we do, and we're just so proud of and satisfied by our work. So what else does an estate planning lawyer do other than get you out of the California default plan? I know that you all have carpools and you probably have glam squads and right? You have teams on teams on teams to achieve your goals. You need a team when it comes to all your professional advisors. It doesn't cost more to get insurance if you go through a broker. TurboTax, you might be missing something. We'd like to introduce you to a CPA. Please don't try to operate a business through an LLC you created on LegalZoom if you think it's giving you asset protection. It won't. I spend a lot of time with other professionals learning how to spot issues in their areas of work, and also so that I can provide the right referral for each client to help them with whatever ancillary issue comes up when we're doing our really invasive first 2-hour meeting and we're asking you a billion questions. I think it's really important that your estate planning lawyer sends some discrete documents to all of your advisors. They're going to help you change title on things, change beneficiary designation on things. Your CPA is a great second set of eyes. Like, why do you own all these things as trustee, but these 2 other things you don't? Is this intentional? Please call Patricia, call Nadia, and get to the bottom of what you should be doing here. The CPA doesn't have the answer, but they can help spot the issue if I give them the tools to do that. It's really important to me that my clients' family members and also the guardians of their children also have estate plans. So I have pretty broad nationwide network because being here in San Francisco, being in California, a lot of people are not from here. And so we've helped family members all over the country find good lawyers where they live. Like what I don't want for my client is they get the call that they have to go to Wyoming, Delaware, Florida, Texas, and conserve parent or go through a terrible probate in another state. It just makes life really, really difficult at an already chaotic time. So how do you know how to find a good estate planning lawyer? Well, Nadia and I are here to help, but maybe you don't like the way we look, you don't like the way we sound. We're just not for you, right? Maybe you're here in the US on a visa and we don't know how to help you. Maybe you have a lot of international assets and we wouldn't be the right lawyer for you. Maybe you have a special needs child and we don't do that work, but we know lawyers who do. You want to ask, do you have a certification? Because you can be a certified specialist in estate planning and also in special needs planning. You can get a master's in estate planning, probate, trust administration, which I have. You can get a master's in tax, which our colleague Wendy Acton has. How long have they been doing this? What is their experience in estate planning? Other practice areas can be tricky. If they're practicing probate, trust administration, and estate planning, those 3 things go together. Maybe they're doing some entity formation. That kind of goes together. But if they're doing bankruptcy and family law and civil litigation, if they're doing too many practice areas, that's not good. That's a red flag and it makes me nervous. I always want you to ask how the documents would be drafted. And I think that every lawyer should use software. It makes me nervous when they don't. I don't want you to work with a lawyer who is using the same form over and over and just plugging your name in, and they're not doing all of the modifications. The software we use is really a powerful tool, and it's very specific as to each client. Ask them how they're going to do the guardianship nomination, because most lawyers, even in California, even though we don't have to, we're still using a will to name guardians, and it drives me up a wall. Do they charge more for plans? I mean, I kind of wrote this a little bit too legalese. Make sure that they're not going to charge you more if you want a plan that deviates from you get your money when you're 25, 30, and 35. If you want to say, my kids can take money out of the trust at certain triggers, I don't want the trust forcing that money out. If the lawyer says, oh, we charge more for that, that makes me uncomfortable. I just don't like it. Ask them how often they're going to follow up with you. Do they have regular check-ins? Do they have a newsletter? Are you going to hear from them? Or is this, because I do know that there are lawyers out there who send a notary to your house with the documents. You sign all the documents and then the notary leaves and you have the only copy of the documents. Please don't work with anyone who does this. Please. Very dangerous. And make sure that your estate planning lawyer is going to collaborate with your financial advisor, your CPA, and your insurance brokers, because all of these things are interrelated and everybody should be talking to everyone else to make sure you're fully supported. Our client experience is pretty robust. We need you for 4 hours, but not all in one day, because that would be horrible. The way that we get to know you is with a 20-minute discovery call, and Nadia can put that link in the chat, and so you can sign up for one of those if you'd like. Our first meeting is 2 hours, and we call it the lawyer's learning meeting. We have some documents we want you to fill out, but they don't have to be perfect. If you're not sure if you want to name Jane then Joan, or maybe Joan then Jane, just list them both and we'll help you through it, because maybe in the end you're going to name Pat and Chris, because you don't really know what the people are going to be doing. And so we're not going to hold you to who's in charge until we get to the client's learning meeting. And that's when we're going to review the documents with you, make sure you understand them, make sure what kind of authority you're giving, that you're comfortable with that, comfortable with the person. And that's where clients really start to take ownership of it. And we see a lot of creativity when it comes to the healthcare directives, the guardianship nomination, and the trust. We can have you sign either online or in person, whatever works best for you. And then we have a meeting that most lawyers don't have, and we want your financial advisor to come to this. We're going to go through your asset sheet that you're going to work with my team over time to perfect, and we're going to go through it with you line by line. What do you do with a bank account? What do you do with RSUs? What do you do with a retirement account? How do you deal with your life insurance? We will talk you through it. And then we'll send you everything that we talked about in that meeting in the ugliest green envelope in the world. And the day that you're done with your funding, you get to celebrate by throwing it away, which is wonderful because it's so ugly. But it's so ugly so that you'll feel bad and you'll do it. And you can't accidentally throw it away and you can't accidentally lose it. We have a client service package that we don't charge for. I find that I don't want to contact my corporate counsel, because if I look at her, she sends me a bill. Our flat fee assumes that you are going to need help over time. We want to hear from you if you're going to buy a house. We want to hear from you if you get a weird form from a bank and you don't understand it. We want to hear from you if you're opening a business, changing jobs. If I can solve a problem or answer a question for you in 5 to 15 minutes, we don't charge for those. And we're happy to answer any kind of a question. You've moved and you want a new financial advisor because you like meeting in person. Great. We probably know someone where you are. So it's just really important for us that we are in contact with our clients all the time, that we want to be your hub. Also, we want to see you every 3 years for that free meeting. We want to double check that the documents are up to snuff with best practices, up to snuff with the law. And then we want to, did anybody here marry a gold digger? Like, what's happening with your people? What has been going on? And here's who we work with. We do a lot of work with married, unmarried, and single people. I just finished work with our very first throuple, and that was very, very fun for me. We do a lot of work with the LGBT plus community. We work with a lot of artists, creators, and performers because my background is intellectual property law and copyright law. So I actually know how to help an artist or a performer protect their person, like their personality, and then also their works. We do a lot of work with divorcing people, of course, real estate owners, because we've got to avoid that probate, right? And then also a lot of business owners. Discounts. Okay, and this is great because it's going to be recorded and we are going to track these numbers. Our flat fees start at $6,300, and that includes the 4 meetings, the notarization, transferring your primary piece of real estate to your trust, a hard copy of your documents in a big, big binder that says very clearly on the front estate plan portfolio and very clearly down the spine estate plan portfolio so people can find it, and absolutely everything in our HIPAA compliant file sharing platform online in the cloud. And the 3 meeting, not just in 3 years, but every 3 years. All of that is included. We will do $1,000 off for the first 10 people to book a meeting before the end of June. And usually I say by the end of this month, but it's May and we're parents and we know what happens to parents in May. It's awful, isn't it? It's tremendous. I'll do 750 for the next 5 who book before the end of June, and then 500 for anyone who books a meeting before the end of June after that. And you can schedule a call now. And look, we're so fancy. We have a QR code. I love it.
Thank you so much, Patricia. This
And
was amazing.
one last thing, please pull out your phones. And if you enjoyed this, if you learned something, please write down the thing that you learned. I want to show our incredible new media director, Ashley, that I'm actually listening to her and that I'm trying to follow her instructions. And I'll stop the share now and we can just talk. We can just talk. And maybe Brooke, we want to stop the recording now so that people feel free to ask maybe more personal questions.
Yeah, that's a great idea. First off, I was just going to say thank you. This was amazing. This is the 3rd time we've done Will's Trust in the States, and this is the most thorough one that I've ever seen.
Oh, I'm so
And really
glad.
thinking about, yeah, like really thinking about like the family members. We were talking about pets at one point. I think there's just a lot more here of digging into it versus just the law. So thank you for that. And I think the biggest thing you put on here is following up because a few people in the beginning said, they've started this a few times. They thought about
Yes.
doing this a full time, and then we know we get carried away with things as parents that are more important. And this is something, frankly, like I want to avoid. So it's just something I need to do, right? Like I need to do it. I can make 1,000 excuses. So this is so helpful to make us want to do it, knowing that there's great questions to ask and things for us to think about. So thanks.
And
But
Brooke, let's talk about timing. Generally, our clients are done between 4 and 12 weeks. Some clients
hmm,
are incredibly speedy and they're just boom, boom, boom. Meeting 1, meeting 2, meeting 3. Some clients it takes a little bit longer. If you have a baby in the house, it's going to take a little bit longer because you're not sleeping, right? You don't have time to talk to each other. But it's rare that a client is more than 12 weeks. We really want to support you to get you all the way through the process. And everybody is assigned a lead attorney, and then the whole team talks about every case on Fridays. The lawyers talk about every case on Fridays. And then we have incredible military spouses who are administrative support. And so everybody has a client liaison. We're not, we take the business side of it really seriously and the customer service side really seriously. So we provide all of our clients, regardless of their asset profile, with a luxury deluxe estate planning experience. We provide what we wish we had had when we got our estate plans done.
exactly. Awesome. Thank you. All right. I'm going to turn off the recording if anyone wants to ask questions. Yes, they can